Good afternoon, everyone. Thank you all for joining our second General Data Protection Regulation webinar. I'd like to present myself. My name is Janus de Visser and I am Data Governance Consultant at Adversitement. And with me is my valued colleague Carolien Toor, Data Privacy Officer of Adversitement. And to introduce the company, Adversitement is a consultancy firm focusing on enabling companies to become data-driven. Our mission is to empower you to deploy the smartest data operations in the world and top quality analytics to create a competitive advantage, improve customer experience and boost your business. All, of course, with the utmost concern for data quality and data ethics. Because the real fun starts when you can rely on your data. Well, as data governance consultant, I support our clients to innovate their data operations while remaining compliant, in control, and protecting privacy. And today we are going to talk to you about the European General Data Protection Regulation, because the rise of big data has immensely changed our lives and will continue to do so for the coming decades. With the explosion of available information and the technology to process these vast amounts of data, we see public opinion and governments getting to grips with the new world. And because information can be as dangerous as it can be helpful, privacy protection has never been so relevant as it is now. In reaction, the European Commission has made a clear stance with the General Data Protection Regulation. One set of rules to protect every European citizen. One set of rules that has serious consequences for all organizations. A lot has been written about it and many summaries have been made, but we experience that most parties have little notion on how to become GDPR compliant. Therefore, Adversitement has made a pragmatic 12-step plan to help organizations prepare for the General Data Protection Regulation. As most of you know, starting May 2018, the GDPR will become enforceable. This is after a 2-year adoption period for companies to become compliant. So as of now, the regulation is active but not enforced yet. And this is what will happen in May 2018. It's our experience, however, that legal departments at most companies have been preparing for the GDPR quite some time already. But this is without the involvement of business or IT. As a result, policies may be defined without the operational feedback, often leaving highly impractical or even impossible to implement processes. Well, to tackle this issue, Adversitement formulated a 12-step plan to become GDPR compliant, because in our opinion, business must remain in the driver's seat, also with the implementation of GDPR compliance. And as a big data service provider for the largest corporations in Europe, we made it our mission to help understand and prepare for the GDPR. So let's kick off the 12-step plan. The General Data Protection Regulation is a big one. It will have serious impact on your organization, and because information flows everywhere, it will reach far beyond the boundaries of just your legal department. This is why our first step focuses on raising awareness. All stakeholders and decision makers in your organization need to be made aware of all new regulatory demands, because these key figures need to assess the consequences of the General Data Protection Regulation on the specific parts of the organization and decide on the next best action. Expect a substantial impact on resources to become compliant, and we strongly advise you to make effective use of the limited time until May 2018 when the regulation will become fully enforceable. So what are we going to do in this time? On to the next step. And the second step is to review your data operations. Not knowing what's going on isn't an option anymore. So start by building a data stream map that documents all personal data processed within your data infrastructure. Such a data lineage audit will result in a good overview and provide the necessary documentation required by the authorities. And remember, this is not solely human resources or customer relation management related. Do not forget your digital channels and digital marketing tools. To do this proper, we advise you to use a data lifecycle as a guide to ask the right questions about how data streams through your organization. Because virtually every piece of data moves through the data lifecycle, but it's not confined to it. The data lifecycle is an ideal type. In your own data infrastructure, the actual data lineage will probably consist of multiple variations of this data lifecycle. It is our experience that especially the repurposing of data happens to create very complex data lineages and opportunity to escape earlier defined and well-intended data governance policies. Besides this data lifecycle, you should also document in your data stream map the following points, one of which is the contact details of the controller, representative and data protection officer, but also the purpose of the processing of the data. You need to go into detail and document the categories of data subjects and what types of personal data is being processed. You also need to define who are the recipients with whom the data may be shared. You need to provide information regarding cross-border data transfers. Will your data also reside in the US or even Russia or Turkey or other complex political structures? You need to document what are the retention periods of this data? How long are you going to work with it and how long will it exist in your data infrastructure? And you need to provide a description of the security measures implemented in respect to the data processed. And to be clear, deleting data is also considered processing of data. We have seen many marketeers trying to find creative solutions to avoid regulations by, for example, erasing the data in transit. But this is also considered processing personal data and all rules still apply. On to step 3 and 4, because we made step 3 about communication. And we made it about communication because transparency is no longer a luxury. With the General Data Protection Regulation, we are obligated to provide information on all your data processing, and this needs to be communicated in a clear and understandable way. To put it simply, every data subject must be able to understand why and how you are using their data. And go back to step 2, because use your data stream map to update your privacy statement with all the data streams and explain the legitimate basis for the data processing. This is also mandatory for all your online endeavors, especially with the proposed European e-privacy regulation. Information and transparency are key. Now, let's move on to the rights of the subject, our step 4. This will be one of the most complex and costly parts of implementing a good General Data Protection Regulation governance. Because with the GDPR, all European citizens have the following rights. They have the right to be informed, meaning, like we mentioned, full transparency and insight in the processing of their personal data. They have the right of access, meaning you should be able to provide access to the personal data you are processing. But there are no guidelines yet on how to actually do this. So we expect lots of trial and error in the coming years. We have to define with us, with each other as an industry on how to do or how to comply to the right of access. Subjects also have the right to rectification, meaning you should be able to make corrections in your data on their request. They have the right to erasure, also known as the right to be forgotten. This is one of the rights everyone is talking about, and it means the obligation to delete personal data when requested by the data subject. There is the right to restrict processing. This is not as intrusive as the right to erasure, but no less complicated to implement. You will be allowed to store the data, but not to further process it. There is the right to data portability, meaning you should transport the data you process to another party on request. And as with the right to access, we expect lots of trial and error on following up such requests in the coming years. There is the right to object, also known as the right to opt out or retract consent, meaning you should stop the processing of one's personal data. And then there is a special one, very interesting for marketeers, and that's the rights related to automated decision making and profiling, because data subjects can object to the automated decisions. Well, these rights propose a serious challenge for nearly all tools, systems and non-digital or dark data. And it is our experience that due to the many processors, sub-processors and cloud solutions operating all together in your infrastructure, that the right to be forgotten is a key feature to implement and focus on. Get that one right and the rest will be relatively easy. The way to get this right is to assess all your data processing parties and partners you documented in your data stream map. Demand from these vendors to implement features that enable your organization to quickly stop data processing, to correct data, to transfer data, to grant access and to delete data. And we want these functionalities without the crippling delays and additional costs we experience so often today. And if you do this assessment right, it might even result in a change of vendor, because your organization simply cannot accept the legal risk and liability by non-compliant partners or burden your own resources by manually answering all data subject related requests. So the assessment of your vendors is key. So when are you allowed or even obligated to process data? That's what our point 5 is about, the legal basis. Because with the General Data Protection Regulation, there must be a legal basis for all processing of personal data. And what is legal basis? Well, there are also multiple conditions under which it's a legal obligation to process personal data. In our previous webinar, we had multiple questions on the combination of the right to be forgotten and the obligation to store and process personal data. And to clarify this, the GDPR is not one regulation to rule them all. The GDPR is also subject to other laws and regulations. For instance, a client can ask to delete their personal data. However, you are obligated to maintain payment records for tax purposes. In such a case, you have to erase everything except that what is obligated to store for the tax authorities. To summarize our step 5, you need to document in your data stream map what the legal basis is on which the purposes of the processing of the data is done for every activity. The regulation has a few options or mentions a few options. You have the contractual necessity that you stated in your contract that you are obligated to process one's data. You have the services you provide to your client or customer so that the data subject can expect you to process their data. For instance, to deliver the order they just made in your web shop. You have your legal obligation, as I just provided in a case. You have vital interests, such as life or death scenarios. And make no mistake, marketing is not that vital. There's also public interest, such as humanitarian emergencies. There is a rather gray area called legitimate interest. We will go into detail on this in a blog probably later on, but you can think of cases such as fraud prevention. And of course, to end, the legal basis is the explicit consent given by a data subject. And that also brings me to step 6. It can be argued that the entire General Data Protection Regulation is focused on consent. A freely given, specific, informed and unambiguous indication of the data subject's agreement to the processing of personal data. And with this, the General Data Protection Regulation protects European citizens and their privacy and allows you to legally and transparently process their personal data. The GDPR requires things like data protection by design and data protection by default. Therefore, in terms of consent, silence, pre-ticked boxes or inactivity do not constitute as consent. It has to be a clear affirmative act of a well-informed data subject. And consent should always be based on opt-in, not on opt-out. The next best action you can find in step 6 to comply to the General Data Protection Regulation is to review the ways you ask, receive and register this consent. In the end, you should be able to demonstrate to the leading authorities that the data subject has given you consent to process his or her personal data. So, what if things go wrong? Because things go wrong and data breaches happen. We see mail attachments to the wrong recipients. We've seen passwords written on post-its and lost. We've seen data sent to the wrong database. There are lost devices and hackers gaining access. And these are all, unfortunately, two common examples of data breaches. And with the General Data Protection Regulation, your organization has obligations to be prepared for these data breaches. And you have to think of processes you have to implement. You have to enable yourself to find and identify these breaches. You have to notify the authority in case of a breach within 72 hours. You also have to communicate this breach to the data subject in case of a high-risk breach, which can lead to personally damaging situations for this data subject. And the documentation of these processes, responsibilities and ownership must be covered and demonstrate that your organization has everything in place to swiftly and correctly comply with the regulation. So alongside your data stream map, we strongly advise a data governance rulebook. And this rulebook is also an insurance necessity. Data breaches are very costly in terms of halted business and resources needed to respond and mitigate. And in such cases you will want to turn to your cyber insurance. But without proper documentation, proving you did everything right, these insurances simply won't pay out. And this is quite a loss, with the average cost of a data breach being around $4 million quoted in an IBM study from 2016. And a few days ago, Reuters mentioned a study done by the Oxford Economics and CGI, who issued a study and found that data breaches cause a permanent 1.8% drop in stock prices due to reputational damage. Data breaches, you need to prepare for them. On to step 8, and this is a personal favorite. And this is a personal favorite because the General Data Protection Regulation tells you to get familiar with privacy by design, or as the regulation calls it, the principles of data protection by design, by default, and privacy impact assessments. Well, these privacy impact assessments must be done with the implementation of new systems, functionalities, or innovations that will process any personal data. The PIA will indicate the risk level of the data processing and give your organization the ability to mitigate this risk with appropriate measures or consultate with the authorities. And data protection by design, on the other hand, constitutes a way of working that requires your organization, when developing, designing, or building their services and solutions, to think of data minimization or pseudonymization of personal data. And data protection by default, on top of that, requires that all options and settings your organization offers in services or products have by default the strictest privacy protection selected. The data subject can then change these settings and provide consent. It's all about opt-in instead of opt-out. To make sure that your organization adopts the principles of data protection and privacy impact assessments, we suggest to provide training for your personnel and also making it part of your data governance rulebook. The Data Protection Officer. This is a new title which was invented specifically for the GDPR. And that's our step 9, because in some cases it's obligatory to appoint a data protection officer in your organization. And this officer will be responsible to uphold the general data protection regulation within the organization, but also act as a representative towards the authorities. And your organization is obligated to appoint a DPO when it's either a public authority or body, or, and here we go again with the gray areas of the legislation or regulation, you have to appoint a DPO when you're processing sensitive data or personal data on a large scale. And on this gray area, in the previous draft versions of the GDPR, there was a clear minimum threshold, which they deleted afterwards. So the definition of large scale will depend on case law and court decisions once the GDPR will be enforced. But to give you an example of what you can think of, in the draft versions they defined it as having 250 employees or more, or having 5,000 data records. That was the minimum defined in the draft version, so that might give a good indication. Then step 10, the international part. We're talking about a European regulation, meaning it's international. There are lots of organizations that are internationally active, and if you're in such an organization, you need to define the leading data protection authority. And in most cases, this will be the authority of the country where your main establishment resides. Next to multiple authorities, you should also be aware that local laws and legislation might give you additional obligations regarding the processing of personal data. So the GDPR is a baseline and local law can still overrule it. So the last 2 steps in our steps to become compliant. Contracts, because it is safe to assume that your organization uses outsourced service providers such as cloud vendors or data experts for data processing, or in legal terms, processors who carry out processing on behalf of you, the data controller. It is our advice to review all contracts and data processing agreements your organization has with its processors and sub-processors. And again, the data stream map with the complete documentation of your data lineage should provide all the information on involved processors and sub-processors whose contracts must be reviewed. And based on our experience, please keep in mind that most vendors will state they have GDPR complying features on their roadmap just to put you at ease. However, you will remain responsible and accountable for the data they process. So you might want to apply some pressure to speed up this development. And last but not least, the rulebook. Establishing an effective data governance to comply with the regulation is not just a one-time exercise. All 11 previous steps must be a continuous part of your data operations, and the requirements, processes, responsibilities and ownership should be gathered and documented in a data governance or rulebook. And before we go to the questions we might have received from our audience, I would like to talk to you about the measures available to data protection authorities. Because we've all talked about the 20 million euro fines or the 4% of the global annual turnover, but those are the extremes, and there is a lot of painful middle ground. And at first, the authority will reprimand you. This is basically stating that they will send you a letter telling how disappointed they are and that you should better yourself. That's the first step. And if you do not react to that in an adequate way, they might order you to rectify or delete the data. And we're talking about data loss already. So after they reprimanded you, they might order you to delete parts of your data collected. And before we go into the fines, there is one thing they can do, and that's put a ban on your data processing. And this can be a temporary or definitive limitation or ban on the processing of personal data. And it doesn't matter how this impacts your products or services. So in the end, an entire business unit could be out of work because they can't provide their service, because they can't process the data they need to provide the service. So before we have the extreme fines, there are very much more costly limitations available to the authorities to enforce the GDPR on your organization. So the fines are just the last step. They're not the end of the story. Okay, next month we have a little teaser for you. We will talk to you about how to improve customer experience within the GDPR boundaries, because we see that the expectations of customers to have personalized interactions are nearly unobtainable, while at the same time they uphold all our organizations up to the highest standards of protecting their privacy and data. And these two expectations seem to be at odds with each other, but we will explain how these two can join in and provide you with innovation without risking any GDPR enforcement. So, to summarize, we had 12 steps going from awareness to documenting all your data streams, to communicating to all your data subjects what you are doing, to making sure your infrastructure is able to uphold or to react to the requests regarding the rights of the subject, that you know and can demonstrate the legal basis on which you are doing all the processing, that you have a proper way of asking and registering consent, that you can, that you have a data breach response plan in place, that you know how to do privacy by design and privacy impact assessments, that you know when to appoint a data protection officer or already appointed one, that you know what the leading authority will be, that you have reviewed your contracts, and that you know how to keep this up in a rulebook. So I would like to thank you all for listening to my story, and now I will give the mic to Carolien answering some of the questions you have asked. So here is Carolien.
Hello everyone. So yes, some of the questions that generally pops up is actually regarding cyber insurances and also the extent of the responsibility of an outsourced service provider. So a question asked regarding cyber insurance is commonly, with companies facing increased obligations and high potential penalties, is it a clever idea to turn to cyber insurances for help? So with the GDPR, it will close up some of the loopholes that have allowed so much cybercrime to go unreported. Previously, as authorities are well aware, some large companies currently make the commercial decisions not to report cybercrime and sweep the data protection breaches quietly under the rug to avoid penalties and damaged reputations. Now, the GDPR obliged companies to notify authorities of all breaches that put individuals at risk within 72 hours. And this is something that is also now being adjusted in the terms and conditions of cyber insurances. Cyber insurances, yes, they can serve an extra protection to leverage the risk of being subjected to potential fines and costs when data breaches occurs, which is basically the failure to proper handle, manage, store, destroy, or otherwise control personal identifiable information. Now, the insurances can also help with appropriate cover for investigation and also defending your position against regulatory fine and penalties that will become critical. However, there are, of course, some requirements that needs to be met of your organization in order to have the full use of the insurance. Firstly, some cyber insurance policies, of course, exclude all wrongful and unlawful collection and handling of data in line with the requirements demanded by the GDPR. Secondly, as mentioned also in the webinar by Janus, your firm needs to ensure that you are doing the right processes for collecting data and that it is documented. This is where the rulebook also serves a proof of document to show that the firm was following all the right procedures against the claim that they are faced. Another following question that is asked is regarding the outsourced service provider. Can we still be held liable for penalties if it is our outsourced service provider who have breached the GDPR law? Well, as mentioned also in the webinar, yes. You will remain responsible and accountable for the data they process for you. And one of the finest cases of this claim was that Nasdaq in Sweden was fined 2.6 million euros due to cyber insecurities failures from an outsourced provider in December 2016. The regulator said it found Nasdaq did not have sufficient basis in their risk management to make the decisions that were made, and also failed to make these demands sufficient to the supplier. It's also found that both firms had insufficient continuity guidelines and emergency plans in case there was a cyber attack. As a final institute that Nasdaq is, this was also considered that the lack of compliant data management would risk the harm of other firms based on the stock exchange was very high. As also revised in the webinar, we advise you to go through all contracts of subcontractors and also that you can demand that they have to be compliant with the GDPR regulation. I will now hand it over to Janus again. Thank you.
So we are at the end of our second webinar on the GDPR. Our third webinar will be probably at the end of May or the beginning of June, and we will communicate with you, of course, the exact date and time of our next webinar. And I would like to thank everybody for their attention and time. The slides will become available online, and there will also be a downloadable white paper with the entire story written out. And once that's available, we will communicate with you where and how to get this. So once again, thanks everyone, and see you next month.